Special Corporate Structure and Dissolution. Title 11 Non-Stock Corporation. Section 86. Section 86 explains what a non-stock corporation is. It is a type of corporation where not part of the income is distributed as dividends to members, trustees, or officers. In other words, nobody profits personally from the corporation's earning. If the corporation earns money incidentally, that profit must be used to support or advance its purposes, such as its charitable or educational mission. The law also says that rules for stock corporation can apply to non-stock corporation as long as they are relevant and not contradicted by specific rules in this title. Section 87. Section 87 tells us why non-stock corporations are created. They exist for charitable, religious, educational, professional, cultural, fraternal, literary, scientific, social, or civic service purposes. It also includes organizations like trade and industry group, agricultural chambers, and similar associations. These organizations must also follow the special rules in this title that may apply to particular types of non-stock corporation. Chapter 1. Members. Section 88. Section 88 talks about voting rights. Member may or may not have voting rights depending on what is written in the Articles of Incorporation or the bylaws. If nothing is stated, each member gets one vote. Voting can be done by proxy, and the bylaws may also allow voting through remote communication or in absentia, unless the corporation's document says otherwise. Section 89 explains that membership in a non-stock corporation is personal and cannot be transferred to someone else unless the articles or bylaws specifically allows it. This means you cannot sell, assign, or pass your membership to another person by default. Section 90. Section 90 states that membership may be terminated according to the rules in the Articles of Incorporation or bylaws. Once someone's membership is terminated, all rights they had in the corporation and its property are extinguished unless the articles or the bylaws says otherwise.
Chapter 2. Trustees and Officers.
Section 91. Election and the term of trustees. In a non-stock corporation, instead of having shareholders like a typical business corporation, it has a member. And the people who manage and make the decision for that corporation are called trustees. The number of trustees is stated either in the Article of Incorporation or the bylaws, but the number cannot exceed 15. Trustees serve for a term of up to 3 years. However, even when their term expires, they stay in position until the new trustees are properly elected. This is to prevent situation where there is no one authorized to manage the corporation. If a trustee leaves before their term expires, like for example, resignation, incapacity, or death, the person who replaced them will only serve the remaining period of the term, not a full 3 years term. Like for example, if X Community Foundation has 7 trustees who are supposed to serve 3 years, but one resigned after 1 year, the person who replaced them will only serve the remaining 2 years. This ensures fairness and prevents extending power beyond what was agreed upon. Section 92. List of members and proxies and place of meeting. A non-stock corporation must maintain an updated list of all members and their proxies. Proxies are people authorized to vote on behalf of a member. The list must be updated at least 20 days before an election. These rules prevent last-minute changes that may lead to unfair election or confusion. Regarding meetings, the law allows flexibility. Meetings do not have to be held where the main office is located as long as the place is within the Philippines, and all members receive a proper notice of the date, time, and venue. The meeting is still valid. For example, even if X Community Foundation is based in Manila, they can hold their annual meeting in Cebu or Davao, provided members are properly notified beforehand.
Chapter 3, Distribution of Assets in Non-Stock Corporation.
Section 93, Distribution of Assets when a non-stock corporation dissolves. If a non-stock corporation decides to close, the law provides a clear order for distributing its assets to avoid misuse. Firstly is pay all the debts and obligation first. The corporation must settle what it owes before anything else. Secondly is return donated assets if required. If an asset was given under a condition such as return this, if the organization closes, then it must be returned. Thirdly is transfer charitable or educational assets to similar organization. Assets meant for charitable, religious, educational, or similar purpose must go to another organization with the same purpose. Lastly is remaining assets go to member only if allowed in the bylaws or articles. If the bylaws allow it, members may receive the remaining assets. If not, members cannot claim anything personally. Like for example, if X Community Foundation owns computers that were donated for free educational program and they dissolve, those computers must be given to another educational charity, not to sold or given to members. This ensures the assets continue serving the community. Section 94, Approval of the Plan of Distribution. To decide how the remaining assets will be distributed, there must be a plan of distribution. This plan must first be approved by the Board of Trustees, must be communicated to all members in a meeting notice, and lastly must be approved by at least 2/3 of the voting members present or voting through proxies. These rules ensures fairness and transparency.
Title 12. Close Corporation.
Section 95, Closed Corporation. A closed corporation is a corporation whose shares are owned by not more than 20 people, often families or long-time business partners. Shares in a closed corporation usually cannot be freely sold to anyone outside the group. There are restrictions to keep ownership and control within the closed circle. Also, the closed corporation do not sell shares to the public and are not listed in the stock market. This makes management more direct, personal, and less formal than by big corporation. Like for example, Y Family Corporation is owned by 5 family members. If one member wants to sell their shares, they must first offer them to the other family members. Outsiders cannot just buy shares without group approval. This prevents strangers from entering the corporation.
Section 96, Articles of Incorporation. This section allows a closed corporation to include a special provision in its Article of Incorporation. It may provide for, first, the classification of shares, their qualifications and restrictions on transfers. Second, the classification of directors into classes elected by the specific groups of stockholders. Third, the stricter quorum or voting requirements that the code normally requires. It may also state that the business will be managed directly by the stockholders instead of a board of directors. In that case, the stockholders are considered both directors and liable as such. Moreover, the article may require that the officer or employees be elected by the stockholders rather than by the board. Section 97. Restrictions on the transfers of shares. Restrictions on the share transfers are valid only if they are clearly stated in 3 places. First, the Articles of Incorporation. Second, by the law. And third, the stock certificates. If not, they are not binding on a good faith purchaser. Also, restriction must not be too burdensome. They can only grant the corporation or existing stockholders the option to buy the shares before they are sold to outsiders. Section 98. Effects of the issuance or transfer in violation of the condition. This section explains what happens if shares are issued or transferred improperly. Shares are transferred to someone not qualified, under the articles, or if the transfer would cause the number of stockholders to exceed 20, the transferee is presumed to have notice of the violation, if the certificate clearly states that the restriction is violated. The corporation may refuse to register such as transfer unless all stockholders consent or the articles are amended to allow it. However, the transferee still retains the right to revoke the transfer or recover the stock under any warranty. Section 99. Agreements by the stockholders. Stockholders in a closed corporation may enter into written agreements among themselves, even before the incorporation, and these remain valid if consistent with the article. They may also agree on how to vote their shares or how to manage the corporation's affairs, even if it limits the board's power. However, when stockholders assume management power, they also take on the liabilities of directors. Additionally, stockholders actively managing the business are held to strict fiduciary duties towards each other. They are personally liable for corporate torts unless the corporation has adequate liability insurance. Section 100. When a board meeting is unnecessary or improperly held. Finally, this section provides flexibility for a closed corporation. Action taken without a formal meeting are still valid if all directors sign a written consent. Second, all stockholders know about it and do not object. Third, the directors usually act informally with everyone's agreement. Or fourth, all directors know and do not object in writing. If a director fails to attend a meeting held without proper notice, the action is considered ratified unless that director promptly files a written objection.
Section 101 Preemptive Right in Closed Corporation. In a closed corporation, existing stockholders have the right to buy new shares first before they are offered to outsiders. This helps keep ownership within the same group. So let's say A, B, and C own a small company. Each has 10 shares. The company wants to sell 9 new shares. Before selling to others, the company must first offer 3 shares to A, 3 shares to B, and 3 shares to C. So in Section 102, Amendment of Articles of Incorporation says that any changes in the Article of Incorporation must be approved by at least 2/3 of stockholders and also by all stockholders unless the article says otherwise. So, example, ABC Closed Corporation, A, B, and C are the only owners. They want to change the company's name from ABC Trading to ABC Supplier. Before doing this, at least 2 out of 3 owners must agree. If only one agrees, the changes cannot happen. So in Section 103, which is deadlocks, this section says that if the owners or directors can't agree and the business is stuck, a stockholder can ask the SEC to fix the problem or even close the corporation if it's needed. So, example is A wants to expand the business, but B and C disagree. Because they can't reach an agreement and the business can't move forward, one of them may ask SEC to help to settle the issue or dissolve the company. So, in Section 104, withdrawal of stockholders or dissolution of corporation, this section says that a stockholder in a closed corporation may withdraw and ask the corporation to buy back their shares for a fair price if there is no agreement that says otherwise. So let's say, for example, A wants to leave the company. He can ask the corporation to buy back his shares at a fair price if no other agreement says otherwise.
Title 13. Special Corporation.
Chapter 1 Educational Corporation.
Section 105 Incorporation. Educational corporation shall be governed by special laws and by the general provision of this code. So, for example, a group of teachers wants to create a new private school. To legally form it as an educational corporation, They must follow both the general rules of the corporational code and the special laws about education, like getting approval from the Department of Education or CHED. So in section 106, Board of Trustees, in this section says that schools are managed by a board with 5, 10, or 15 members who serve for 5 years, with one-fifth replaced yearly. A majority must be present to decide. So let's say, for example, is ABC Learning Academy is a non-stock educational corporation with 10 trustees. Each trustee serves for 5 years. Every year, two trustees, which is the one-fifth of 10, finish with term. So when that happens, the school holds an election to replace them or to re-elect the same people if they are chosen again. So during the election or any meeting, at least 6 trustees, a majority, must be present for the decision to be valid. This system ensures that the leadership management remains stable and continues every year.
Chapter 2 Religious Corporation.
Section 107. Section 107 explains that religious organization can become legal entities called religious corporation. They may be formed by one or more persons and are classified either as a corporation sole or as a religious society. This corporation must follow this chapter and the general rules for non-stock corporation to ensure proper governance and accountability. Section 108. Section 108 introduced that the corporation sole where a single religious leader, such as bishop, priest, minister, or rabbi, forms a legal entity to manage the affairs and properties of the church or denomination. This ensures continuously and properly administration of church assets for the benefit of the religious community. Section 109. Section 109 lists what must be included in the Articles of Incorporation of a corporation sole. The religious leader must affirm their authority, confirm that their church allows incorporation, describe their administrative responsibility, explain how leadership vacancies are filled, and state the location of the principal of office. These details guarantee transparency and proper structure. Section 110 explains the process of filing the Articles of Incorporations. Once the documents and proof of appointment are submitted and verified, the religious leader officially becomes a corporation sole. All church properties they manage are held in trust for the exclusive benefit of their denomination and institution. On Section 111 states that a corporation sole may acquire, hold, or receive properties for religious or charitable purposes. It may sell or mortgage its properties with court approval unless the church-owned rules already govern this transaction, in which case court intervention is not needed. This protects both church autonomy and community interest. And Section 112 provides that when a new religious leader is in office, they automatically became the corporation sole after filing their appointment. During vacancies, the person designated by the church rules will temporarily manage the corporation's properties and affairs to ensure continuity and stability.
Section 130. This section talks about the dissolution of sole corporation. The religious leader of the corporation must file a verified declaration of dissolution to the commission. Remember, dissolution does not mean it is automatically terminated. It goes through a process. The declaration must have the name of the corporation, the reason of dissolution and winding up, the authorization for the dissolution of the corporation by the particular religious denomination, sect, or church, and the names and addresses of the persons who are to supervise the winding up of the affairs of the corporation. Once the commission has approved, only then the corporation stop operating and only work for the winding up, for settling the remaining affairs. Only then it will be terminated. Move on to section 114. This is the incorporation of religious societies. It allows religious groups, example, dioceses, synods, may incorporate if not forbidden by their internal rules or authorities, at least 2/3 of the members consent or vote in favor, must file verified articles of incorporation with commission stating religious identity and purpose, membership, approval, compliance with internal rules, location of the principal office, the names, nationalities, addresses of the trustees that is more than 5 but less than 15%. Chapter 3. Chapter 3 Corporation. Chapter 3. So move on. Chapter 3, Section 115. Applicability of provision to one-person corporations. So this chapter mainly applies to the one-person corporations. Other parts of the corporation code can still apply except as otherwise provided in this title. Section 116. One-person corporation. One-person corporation is a corporation with only one stockholder. Only a natural person, trust, or an estate can form a one-person corporation. So who cannot form a one-person corporation? It is the banks, insurance companies, publicly listed firms, and certain government corporations. Individual, professional like doctors, lawyers cannot form a one-person corporation to practice their profession unless provided under special laws. Section 117. It is minimum capital stock not required for one-person corporation. This section says one-person corporation doesn't have a required minimum authorized capital stock to start unless provided by special laws. This makes it easier for small entrepreneurs to start a business without needing a big capital. Section 118. Articles of Incorporation. One-person corporations must file articles of incorporation in accordance with the requirements under Section 1(4) of this code. So this code says, if the single stockholder is a trust or an estate, they must include the name, nationality, and residence of the person managing it, with the proof that they are authorized to act on behalf of the trust or estate. And it must include the name, nationality, residence of the nominees and alternate nominee, and the extent, coverage, and limit of their authority. It is to ensure the continuity of the corporation so that someone is ready to take over in case of the owner dies or cannot manage the business. Section 118, Bylaws. When we say bylaw, it is the internal rules and procedures that guide the decision-making process of a certain corporation. One-person corporations is not required to submit and file corporate bylaws because there is only one owner.
Section 120. Display of corporate name. This section requires that every one-person corporation, or OPC, must clearly indicate that it is an OPC by adding the letters OPC to its name. This can be placed under the corporate name or at the end of it. This rule ensures that the public immediately knows the company is owned and controlled by only one person. Section 121. Single stockholder as director and president. First up, in an OPC, the single stockholder automatically wears two hats, the director and president. That means that they run the company and make the decisions themselves. No board of directors needed. Everything is under one person's control. Section 122. Treasurer, corporate secretary, and other officers. Even though there's only one stockholder, the OPC still need other officers. Here's what happens. Within 15 days after incorporation, the corporation must appoint a treasurer, a corporate secretary, and any other officers it needs. The SEC must be notified within 5 days. The important rule is that the single stockholder cannot be the corporate secretary, but they can be the treasurer as long as they give a bond to the SEC, promise in writing to handle the corporate money properly, and renew that bond every 2 years or as needed. Section 123. Special functions of the corporate secretary. This section is all about the corporate secretary, and their main jobs are keeping the minutes and records of the corporation. Also, if the single stockholder dies or becomes incapacitated, they notify the nominee or alternate nominee within 5 days. They also notify the SEC of the stockholder's death within 5 days and provide the names and contact info of the legal heirs. They will call a meeting with the nominee, the alternate nominee, and the heirs to guide them on electing a new director, amending the articles, and other related matters. Section 124. Nominee and alternate nominee. This section introduces the nominee and alternate nominees, and here's how it works. The single stockholder must name a nominee and alternate nominee in the articles of incorporation. These people step in if the stockholder dies or cannot perform their duties. The nominee manages the corporation temporarily until the legal heirs decide who will take over as the new stockholder. If the nominee cannot serve, the alternate nominee steps in, but only under the same rules and conditions as the nominee. Chapter 126. Change of nominee or alternate nominee. This section allows the single stockholder to change their nominee or alternate nominee anytime. All they have to do is submit the new names with written consent to the SEC. No need to amend the articles of incorporation. It's that simple.
Section 127 tackles the minute book. A minute book is a formal record of a corporation's important legal and administrative documents, including meeting minutes, articles of incorporation, bylaws, and share ledgers. Now, Section 127 states that a one-person corporation shall maintain a minute book which shall contain all actions, decisions, and resolutions taken by the one-person corporation. Section 128 tackles the records in lieu of meetings, which refers to documenting decisions through written consent instead of holding a formal meeting. Section 128 states that when an action is needed on any matter, it shall be sufficient to prepare a written resolution, signed and dated by the single stockholder and recorded in the minute book of the one-person corporation. Section 129 tackles the reportorial requirements. The first requirement is the annual financial statements audited by an independent certified public accountant. Provided in the statement is that if the total assets or total liabilities of the corporation are less than 600,000 pesos, the financial statements shall be certified under oath by the corporation's treasurer and president. The second requirement is a report containing explanations or comments by the president on every qualification, reservation, or adverse remark or disclaimer made by the auditor in the latter's report. The last requirement is a disclosure of all self-dealings and related party transactions entered into between the one-person corporation and the single stockholder, and other reports that the Commission may require. For the purpose of this provision, the fiscal year of a one-person corporation shall be set forth in its articles of incorporation or, in the absence thereof, the calendar year. The Commission may place the corporation fail to submit the reportorial requirements 3 times consecutively or intermittently within a period of 5 years. For Section 130, this tackles the liability of a single shareholder. A sole shareholder claiming limited liability has the burden of affirmatively showing that the corporation was adequately financed. Where the single stockholder cannot prove the property of the one-person corporation is independent of the stockholder's personal property, the stockholder shall be jointly and severally liable for the debts and other liabilities of the one-person corporation. The principles of piercing the corporate veil applies with equal force to one-person corporations as with other corporations. For Section 131, this tackles the conversion from an ordinary corporation to a one-person corporation. When a single stockholder acquires all the stocks of an ordinary stock corporation, the latter may apply for conversion into a one-person corporation, subject to the submission of such documents as the Commission may require. If the application for conversion is approved, the Commission shall issue a certificate of filing of amended articles of incorporation reflecting the conversion. The one-person corporation converted from an ordinary stock corporation shall succeed the latter and be legally responsible for all the latter's outstanding liabilities as of the date of conversion. Section 132 is the opposite of Section 131. This section states the conversion from one-person corporation to an ordinary stock corporation. A one-person corporation may be converted into an ordinary stock corporation after due notice to the Commission of such fact and of the circumstances leading to the conversion, and after compliance with all the other requirements for stock corporations under this code and applicable rules. Such notice shall be filed with the Commission within 60 days from the occurrence of the circumstances leading to the conversion into an ordinary stock corporation. If all requirements have been complied with, the Commission shall issue a certificate of filing or amended articles of incorporation reflecting the conversion. In case of death, if the single stockholder, the nominee, or alternate nominee shall transfer the shares to the duly designated legal heir or estate within 7 days from the receipt of either an affidavit of heirship or self-adjudication executed by a sole heir, or any other legal document declaring the legal heirs of the single stockholder, and notify the Commission of the transfer. Within 60 days from the transfer of the shares, the legal heirs shall notify the Commission of their decision to either wind up and dissolve the one-person corporation or convert it into an ordinary stock corporation. The ordinary stock corporation converted from one-person corporation shall succeed the latter and be legally responsible for all the latter's outstanding liabilities as of the date of conversion.
Title 14, Dissolution.
Moving on to Title 14, we would now discuss dissolution. Dissolution here in corporation is different from the dissolution in partnership, since they have different grounds. In a corporation, it is the extinguishment of franchise and the termination of its corporate existence. It may only come to an end, or the life will be extinguished only by the act or with the approval of the sovereign power, and it can be dissolved with the consent of the state. So that's what dissolution is in a corporation. Section 133, Methods of Dissolution. A corporation formed or organized under the provisions of this code may be dissolved voluntarily or involuntarily. So the first section in this chapter, which is section 133, introduces the methods of dissolution in a corporation or organization, which are voluntarily and involuntarily. Further information about these two methods will be discussed thoroughly in the following sections. Starting off with section 134, voluntary dissolution where no creditors are affected. So in this section, it discusses that a private corporation may be dissolved voluntarily without the necessity of going to court, since the dissolution does not affect the rights of any creditor against the corporation, because there is consent from them. So the effect of voluntary dissolution is that it requires the majority vote of the board of directors or trustees, and a resolution approved by stockholders owning at least a majority of the outstanding capital stock or majority of the members. Aside from that, this section also provided the requirements and procedures to legally dissolve the existence of the corporation without prejudicing the rights of the creditors. First on the list is it must be initiated by a resolution adopted by the majority vote of the board of directors or trustees. Second, there must be a notice given to each shareholder or member stating the meeting's purpose, time, and place, and this notice shall be given at least 20 days before the meeting. Third, it must be approved by the affirmative vote of the stockholders owning at least the majority of the outstanding capital stock. Fourth, there is a verified request to the SEC or the Security Exchange Commission and must be filed them so it could be verified or it was made under the oath. So for this request to be verified, it must contain the specific details of the dissolution, such as the reason for dissolution, the form, manner, and the time when the notices were given, the name of the stockholders and directors, the date, place, and time of the meeting in which the vote was made, and the details of publication. Fifth procedure is the corporation will now submit the copy of the resolution, the proof of publication, and the favorable recommendation from the regulatory agency only when it's necessary. So those three will be submitted to the SEC. And lastly, if there's no withdrawal within 15 days from the receipt of the request for dissolution, the SEC will now approve the request and will issue the certificate of dissolution since all of the requirements have been met and there are no such objections. Section 135, Voluntary Dissolution, where creditors are affected. Procedure and contents of petition. So by this section's title itself, it's already evident that this is the opposite of Section 134 since the creditors here are now affected by the dissolution. And because of that, the corporation must submit a formal or sworn statement or petition to the SEC requesting permission to dissolve the corporation. So like Section 134, this section also has procedures and requirements to legally dissolve the corporation. First, there must be a meeting of the stockholders or members for the approval of the dissolution. And this approval or decision must be backed by a majority vote, or at least 2/3 of the outstanding capital stock, or by its members. Second, a petition for dissolution must be signed by a majority of the corporation's directors or trustees. It must be verified by the corporation's president or secretary, or even one of its directors or trustees. And the petition must include all claims and demands against the corporation, essentially laying bare all of its debts and liabilities. This petition must include the specific details, such as the reason for dissolution, the form, the manner, the date, the place, the time when the notice were given. And other than that, there's also accompanying documents to the petition, which are the copy of the resolution authorizing the dissolution and the list of all its creditors, since this petition must ensure the transparency and the compliance with legal requirements. Third, once the SEC receives the petition, they will review it for its sufficiency, and if it meets the requirements, the SEC will now issue an order that states the petition's purpose, and they will also set a deadline. And this deadline is usually between 30 and 60 days after the order's issuance for objections, to give creditors and other interested parties a chance to voice concerns, since they are affected by the dissolution. To ensure everyone is informed, the SEC mandates that this order be published at least once a week for 3 consecutive weeks in a newspaper or general circulation in the area where the corporation's main office is located, and also posted in 3 public places in that same area for 3 consecutive weeks. After the objection deadline passes, the SEC holds a hearing to consider the petition and any objections raised. If the SEC finds the objections invalid and the petition's information truthful, it issues a judgment dissolving the corporation. This judgment can also include instructions on how the corporation's assets should be distributed to pay off its debts, and the SEC might appoint a recoverer to oversee this entire process. However, the dissolution is not final until the SEC issues a certificate of dissolution, which is the official document that marks the legal end of the corporation's existence. Section 136 of the Revised Corporation Code outlines a specific method for voluntary dissolution, shortening the corporation's term as stated in its articles of incorporation. This section allows a corporation to effectively dissolve itself by amending its foundational document to specify a shorter lifespan. The process begins with the corporation formally amending its articles of corporation, following the standard amendment procedures outlined somewhere in the code. A crucial step is then submitting a copy of these amendment articles to the Securities and Exchange Commission, or SEC, ensuring that the change to the corporate term is officially recorded. So once the shortened term, as specified in the approved amended articles, expires, the corporation is deemed dissolved without any further action required. There's no need for additional resolutions, petitions, or SEC orders. However, this automatic dissolution is subject to the provisions of this code on liquidation, meaning the corporation must still properly wind down its affairs, settle its debts, and distribute any remaining assets to its shareholders according to the legal requirements for liquidation. So, in short, Section 136 provides a streamlined way to dissolve a corporation by their shortening its term or simply allowing its original term to expire. emphasizing the automatic nature of the dissolution while still requiring adherence to liquidation protocols.
Section 137 explains that if a company decides not to dissolve anymore, it can withdraw its request within 15 days by submitting a verified written withdrawal. For example, if new investor comes in, the company may change in mind and continue operating. Section 138 is about involuntary dissolution. This happens when the SEC or another party files a complaint due to fraud, illegal acts, or failure to operate. For instance, if a company is found guilty of money laundering, the SEC can dissolve it and transfer its asset to the government, except for what's owed to innocent employees or shareholders. Section 139 covers corporate liquidation. Even after dissolution, the company continues for 3 years but only to settle debts, sell assets, or distribute remaining properties. If there are assets left for unknown owners, these are given to the government. In short, this section ensures that corporations can exit the market properly, protect creditors and shareholders, and prevent misuse of corporate privileges.